Good morning for some and good afternoon for others, and welcome to our presentation on best practices in drafting U.S. government subcontract terms and conditions. My name is Erin Toomey, and I'm a partner at the law firm of Foley and Lardner, and I specialize in government contracts law here out of our office in Detroit, Michigan. With me here today is my fellow partner, Vanessa Miller, who is a commercial litigator and also practices out of Foley's Detroit office. For those of you who are located in and around Detroit, Michigan, Vanessa and I gave a similar presentation in person in October of 2014. But we wanted to provide our clients and contacts outside of Michigan or who are not able to make it that day with the same benefit of the training. So if you attended the training in person in October, this may be a bit of a review for you, and for everybody else, welcome. For those who are looking for continuing legal education or CLE credits, today's program will run for 90 minutes, and we will apply for 1.5 general CLE credits. Anyone wishing to receive credit for today's program must enter the code when announced during the polling question. All New York, New Jersey, and Kansas attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code. The attorney affirmation form and today's slides can be obtained in the resource list widget at the bottom of your screen. For New York attorneys, those of you with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be emailed to Christina Wade at cwade, W-A-D as in dog, E, at foley.com. During the web conference, questions can be submitted by entering them through the Q&A widget, which is open on the left side of your screen. We'll answer questions throughout the session and at the end of the presentation as time permits. The purpose of today's presentation is to discuss the key terms and conditions in government subcontracts and how to draft subcontracts to reduce risk from both the perspective of prime contractors and subcontractors. Since government contracts contain both government contract-related laws, regulations, and clauses, as well as standard commercial clauses, we consider them a hybrid between a government contract and a commercial contract. I today will address the FAR clauses and other government unique requirements, and Vanessa will discuss the commercial contracting principles and clauses, and together we'll discuss how to reconcile the two regimes to best draft subcontracts. Today we'll be focusing mainly on warranty, changes, termination for default, and termination for convenience clauses. We'll also talk about innovative techniques to reduce risk, such as through limitation of liability and limitation of remedy clauses, which will enable the prime contractor to transfer risk to the subcontractor and also to enable the subcontractor to manage the level of risk it's willing to accept from the prime. You'll note as we go through the presentation that there are several slides that reference different requirements for commercial item contracts. For those of you who are newer to government contracts, there's a concept known as commercial item contracting, and that enables a company to do business with the federal government on terms and conditions that more closely resemble those in the commercial marketplace, and that avoids the application of some onerous government unique requirements. We don't have time today to discuss what constitutes a commercial item, but if you go to Foley's website and look up my bio under Erin Toomey, you'll see a few articles that I've authored on commercial item contracting, and those should be able to provide you with some good background. Last, during the presentation, you'll see references on the slides, and we'll make reference to prime contracts or prime contractors. When we talk about the prime and how to draft subcontracts to reduce risk from the prime's perspective, it also applies to any other higher tiered subcontractor. So let's say you're a first-tier subcontractor in the chain, but you need to flow down these clauses or requirements to your subcontractors. In the presentation, you would be considered the prime. And that's just for ease of reference so that we don't get too wordy when we talk about prime contractor and higher-tiered contractor. So first we're going to talk about FAR clauses and the Uniform Commercial Code. The formation and administration of U.S. government prime contracts are subject to and governed by the Federal Acquisition Regulation and 20-plus agency FAR supplements. The FAR went into effect in 1984, and the original purpose of the FAR was to consolidate the numerous individual agency regulations into one comprehensive set of standards that would apply government-wide. Well, unfortunately, after the FAR was promulgated, nearly every major cabinet-level department and many agencies below them had issued supplemental regulations, which often placed further restrictions or requirements on contractors and contracting officers. So although one example is the Department of Defense FAR supplement, which is actually thicker than the FAR when you look at them side by side. Some agencies are exempt from compliance with the FAR. Those are Federal Aviation Administration, U.S. Mint, the U.S. Postal Service are just some examples. But you often will see that the contract clauses that they use often mirror the language in the FAR. The FAR and a lot of these agency supplemental regulations are available at either www.acquisition.gov or www.gpo.gov. And at those websites, you can both find the current version and archive versions of the FAR and agency supplements. FAR Subpart 52.2 contains contract clauses and solicitation clauses. There's a policy citation before each clause, and that tells you when the clause should be included in a prime contractor solicitation. Often the application of the clause depends on the contract type. For example, is it fixed price, cost reimbursement, a commercial item, etc. The type of work to be performed, is it a sale of goods, provision of services, construction, and also total anticipated value. When you look at total anticipated value, they take into account the base contract plus all options to determine if you trigger the applicable threshold. Government contracts, statutes, laws, regulations, and rules apply to a government subcontract to the extent that they're actually incorporated in the agreement. The word subcontract is defined in FAR 44.101 as any contract entered into by a subcontractor to furnish supplies or services for performance of a prime contract or a subcontract. It includes, but is not limited to, purchase orders and changes and modifications to purchase orders. So I have a lot of clients who say, well, I don't have a subcontract, I just have a purchase order. And I have to say, well, under the FAR, a purchase order is a subcontract that will often have FAR, DFAR, other agency supplemental clauses in them. Note that although there's multiple uses of the word subcontract and several definitions of the term subcontract in the FAR, there actually is very little case law about what constitutes a subcontract and who is a subcontractor. For example, several of my clients struggle when they purchase goods and keep them in inventory and then use them in their performance of a government contract. Are those purchase orders issued to those inventory suppliers government subcontracts that should include all these flowdowns? And that's not really a clear issue. It's not really defined in the FAR, and there's an industry practice that we use, but it's not well defined in the FAR or in cases. In terms of a subcontract, typically you only need to comply with what is in your subcontract. There is something called the Christian Doctrine, which is based on the case of G.L. Christian and Associates. That is from 1963. And that case had to deal with a termination for convenience clause that was not in the prime contract. And the government terminated for convenience. And the contractor said, well, that wasn't in our contract. And it was held, the court held that there are certain clauses that are fundamental to federal government contracting. And those clauses will be read into the contract even if they're not actually in there. That actually has never been applied at the subcontract level, even though it has been applied at the prime contract level to many other FAR clauses. However, in March of 2013, the D.C. Circuit had a case, UPMC Braddock versus Harris, which involved the equal employment opportunity requirements under Executive Order 11246. The regulations implementing that executive order state that the requirements apply even if the contract clause is not included in a contract. Therefore, it is read into all prime contracts and subcontracts. Based on that, as well as the Christian Doctrine, the court held that the equal opportunity clause was read into the contract. This is the first case where the Christian Doctrine has been held to apply at the subcontract level, but frankly, we think it's limited to that equal employment context where the regulations specifically state that the clause applies even if they're not in the contract. From the prime contractor's perspective, the prime contractor is the one who usually has the most bargaining power. There are some clauses in the prime contract that the prime must flow down to its subs or they'll be in breach. Usually what you do is you take a look at the FAR clause, and it's usually the last paragraph, although sometimes it's buried in there, will tell you whether or not the clause needs to be included in subcontracts, and if so, what type of subcontracts. Keep in mind, however, not all provisions or FAR clauses must be or even can be flowed down. So, for example, the electronic fund transfer provisions that provide for payments through the system for award management, that only applies to prime contractors because that's not how a subcontractor gets paid. A subcontractor gets paid from the prime contractor directly. Similarly, the disputes clause. The disputes clause only applies to prime contractors. So if that is the only disputes mechanism you have in your contract, as a subcontractor, that really leaves you without an avenue to pursue disputes against the prime. Also, since a subcontract is likely only for a subset of the prime's requirements, some provisions are not likely applicable. So, for example, if the prime contracts a cost-type contract and the subcontract is fixed price, the subcontractor should reject the cost allowability or unallowable cost type clauses or other clauses that are only for cost reimbursement contracts. Similarly, if the prime contract is a non-commercial item contract, but the subcontract is a commercial item subcontract, the subcontractor should only accept those clauses that are required for commercial item subcontracts. Last example is if the prime contract is for the performance of services primarily, but the subcontract is for the purchase of materials and there's no services involved, the subcontractor should reject the clauses that apply to services, such as the Service Contract Act clause. Also, from the prime's perspective, there are other clauses which, although they're not mandatory, should be modified and slowed down to protect the prime's interest from a business perspective, and those are the ones that we're mainly talking about today. That's termination for default, termination for convenience, stop work order, changes, indemnification, and warranty. These FAR clauses actually do not state that the prime contractor has to include them in subcontracts, but if you think about it, the prime contractor is at risk financially if they do not flow them down. And let's take an example. If the government terminates for its own convenience the prime contract, but the prime contractor has not reserved that right in its subcontract, the prime contractor needs to stop all work and direct its subcontractors to stop all work. Well, the prime then has two options. Number one, direct their subcontractor to stop work, in which case it's most likely breach of contract between the prime and the sub, and the prime contractor would then have to pay for the subcontractor's lost profits, which is not something that the prime can get reimbursed from the government in a termination for convenience. So that leaves the prime financially exposed. From the subcontractor's perspective, the subcontractor needs to accept the clauses that the prime must include to cover its legitimate risk, and those are some of the ones on the prior page. If you know that the prime contractor must accept a termination for convenience from the government, then the subcontractor knows that that needs to get slowed down. The subcontractor needs to be able to identify the clauses that are not mandatory flowdowns and do not cover a prime's legitimate risk, and that will cause a burden on the subcontractor. And one of those examples is set-off rights. That's not something that is a required flowdown. It's not something that the government gets under a prime contract. But to the extent the prime's trying to get that from the sub, in certain circumstances, that may be an area to push back. The main challenge is for the subcontractor to convince the prime that these superfluous clauses add unnecessary costs and are overly burdensome or just unfair. And one of the examples is a commercial item subcontract. If you have a commercial item subcontract and the prime is trying to include clauses that are inappropriate for a commercial item contract, then you essentially are losing the benefit of that commercial item status. And some of those clauses would be the Truth in Negotiations Act, cost accounting standards, requirement to have a small business subcontracting plan, etc. It's also important for the subcontractor to recognize when the government or when the prime needs to flow down a clause so that the subcontractor does not waste its time trying to negotiate clauses that are unnegotiable. Another consideration for a subcontractor is whether, once it accepts a clause, it will be able to flow down that clause and that risk to its own lower-tier subcontractors. So, for example, before you take on a FAR clause, if if the FAR clause requires you to include that clause in all subcontracts, you need to think about whether or not that is something that your subcontractors will accept. Okay, I'm now going to turn it over to Vanessa to start talking about the Uniform Commercial Code.
Thank you, Erin. In addition to the FAR, U.S. government subcontracts are also governed by commercial law and the Uniform Commercial Code. So when we're talking about the Uniform Commercial Code, we're going to focus specifically today on Article 2 of the UCC, which applies to the sale of goods. Services are governed by state law, and because we want to look at a uniform code for today's purposes, we're going to focus on the sale of goods. Oftentimes there will be goods and services involved in a contract. We look to see whether these services are ancillary to or secondary to the sale of the goods, such as are the services merely delivering the products, some form of maintenance with respect to delivery of a machine, training services, or maybe even something as small as software updates. Those types of services likely will be found to be ancillary to the goods. Therefore, both the sale of the goods and related services are going to be governed by Article 2 of the UCC. The UCC has been enacted in all 50 states, as well as D.C., Puerto Rico, and the U.S. Virgin Islands. The goal behind the UCC was to harmonize state law because so much of the sale of goods involves interstate transactions, where there's different states that span from the manufacture, storage, purchase, to the sale of the goods. When we're talking about terms and conditions under the UCC, the first step usually involves whether or not there's a battle of the forms dispute. This is a dispute involving which party's terms and conditions govern the agreement. During the contracting process, parties often use form documents. We'll see requests for proposals or requests for quotation, and then quotations or bids, purchase orders, and then award letters, and then invoices issued by the seller after delivery of the goods. Now, businesses would come to a screeching halt if every single time there were goods purchased, there had to be a specifically negotiated set of terms and conditions. We understand that. So we know how important form documents are. But each of these form documents will contain their own standard terms and conditions. They may be attached on the back side of the purchase orders. Or sometimes we'll see a reference to the party's terms and conditions available on their website. And most of the time, the incorporated terms and conditions, as you would expect, are more favorable to the party offering the document. So the seller's terms and conditions are very seller-friendly. And then the buyer's terms and conditions are drafted to give them every advantage over the sellers. Both sets of terms and conditions usually will state that they are exclusive, and that by issuing the purchase order or the start of production of the goods, that all competing terms are rejected. And it's these types of competing forms that lead to the much litigated battle of the forms dispute. Now, I should state that if you can get express agreement from the other side as to whose terms are going to apply, then those terms will be the terms that govern the contract, and there will not be a battle of the forms dispute. But more often than not, it is the parties are looking to their standard forms to see whose terms govern and whether additional terms are accepted or not. The UCC has a provision that talks about additional terms, 2207. And if the terms are different under the UCC, then they'll just cancel each other out, and you'll just be left with the gap-filling provisions of the UCC. But if the terms are additional, the UCC sets forth a specific criteria for determining whether and when the additional terms are accepted or confirmed. For contracts between merchants, it's presumed that additional terms set forth in a confirmation or acceptance are effective unless one of the following three circumstances occurs. First, the offer expressly limits acceptance to the terms of the offer. Second, the additional or different terms materially alter the contract. There's a lot of case law on what can materially alter a contract, everything from an arbitration provision to a delivery requirement can be deemed to have materially altered the contract, but it's a pretty fact-specific question. And then the third circumstance is notification of objection to the additional term. So you receive notice that there's an additional term, and within a reasonable amount of time, you send a letter or an email rejecting the application of that term. Under those three circumstances, the changes will not be deemed to be, the additional terms will not be deemed to be accepted. The UCC is, in general, going to look beyond the form language of the parties' competing terms and conditions, and is also going to look at what the parties actually did. How did they conduct themselves? Maybe there's a delivery requirement set forth in the contract, and the other side has a competing delivery requirement in their contract, but if you proceeded to operate under, for example, the buyer's delivery requirements, then that will be the term that will be considered to govern. The key takeaway with respect to terms and conditions and the battle of the forms is if a term is essential, you need to be sure to negotiate it explicitly and obtain the other party's consent, or else you can find yourself in a battle of the forms dispute. With that framework in mind, the battle of the forms framework and then the caveats, let's turn to specific terms and conditions. One of the key terms that we look at when we review contracts, long-term agreements that clients have are the warranty provisions. Warranties are obligations that a party undertakes by agreement or that are imposed by law. There's two types of warranties. There's express warranties and then implied warranties. And in general, warranties are very important to contracts because they are supposed to provide an objective measurement for performance under a contract, something that you can look at and point to and say, this was met or this was not met. With respect to express warranties, these are promises that a seller makes concerning goods sold to a buyer. They arise from affirmations of fact, and they can be created by anything from oral statements to advertisements to specifications or drawings. In the law, we look from general to specific. So if there's a statement in the contract that the part will work, the components will be free from defect, that's a more general statement. What the court's going to look at and what the parties should look at are the more detailed specifications as to what it really means for the part to work. If there's hundreds of pages of detailed specs provided by the buyer to the seller, then what it means for it to be free from defect and work is really what's set forth in those specs. There's no magic language needed to create a warranty. You don't need to say warrant or guarantee. But in general, if the goods performance is described, then the goods need to conform to that description. And then we always tell our clients it's important to distinguish between puffing and express warranties, or else all the sales folks would be out of jobs. Puffing is kind of the trade talk and bragging or opining about a product, whereas warranties are more specific and they have to be measurable and describe some aspect or performance criteria of the product in order to be found to be express warranties. A common question is, what is the minimum warranty period that I can extend to a buyer? And under the UCC, there is no minimum amount of time that a product has to be warranted, absent some other applicable regulation or law. Instead, it's really the marketplace that's going to govern what a minimum acceptable warranty period is. The seller is always going to try to offer the shortest warranty period while still maintaining sales in the marketplace. And then the buyer is going to want as long of a warranty period as they can possibly negotiate to protect themselves from warranty issues downstream. It's important to look at the longest time period that the buyer's customer may be required by contract or law to repair or replace the goods. So you should take into account the prime's manufacturing process. For example, assuming the prime gives a 12-month warranty, if the prime receives a component from the sub 6 months prior to that time, then you'll need an 18-month warranty from the sub. So for this reason, we caution clients against entering into having standard warranty periods because it's not really a one-size-fits-all type of situation. You need to really look at the end use of the product, who your customer is, in order to determine the appropriate warranty period for the sub-supplier. Turning to implied warranties under the UCC, there are two types of implied warranties. And the first is the implied warranty of merchantability. Unless disclaimed, there's a warranty that goods must be merchantable, as long as the seller is a merchant with respect to goods of that kind, a seller that deals in goods of that kind, which is typically what companies are that are selling goods. And if there's a warranty of merchantability, the goods need to be reasonably fit for ordinary purposes for which such items are used. Now, that's been expanded a bit to mean a number of things. Merchantable goods have to pass without objection in the trade under the contract description. They have to be of fair or average quality within that description. They have to be fit for the ordinary purposes for which such goods are used. They have to run within allowable variations under the agreement and be of even kind, quality, and quantity. They have to be adequately contained, packaged, and labeled. And they also need to conform to any promises or affirmations of fact made on the container or label. So that's a lot bundled up under the implied warranty of merchantability. Very broad. So we always caution sellers that if you don't want to live in this vague, broad world of implied warranties and merchantability, make sure to disclaim that implied warranty in your contract, or else there's a lot you can shoehorn in there if you're a disgruntled buyer. We'll talk more about disclaimer later. There's also implied warranty of fitness for a particular purpose under the UCC. It's the second type of implied warranty. This is different in that the goods need to be fit for the purpose for which they were intended. This arises only when the seller knows or has reason to know the particular purpose for which the goods are required. And then the buyer is relying on the seller's skill or judgment that the goods will be fit for those purposes. So there's a reliance factor that's involved with respect to the fitness for a particular purpose warranty. If you don't know what the goods are going to be used for, if you don't know what the government's using the product for, then be sure to disclaim this warranty. And unlike the implied warranty of merchantability, the warranty of fitness does require reliance. I'm going to turn it back to Erin to talk about the FAR.
So surprisingly, or maybe not for some, the use of warranties is not mandatory under the FAR. The FAR does provide that warranty clauses do not limit the government's rights under an inspection clause if there's any latent defects, fraud, or gross mistakes amounting to fraud. And in terms of the scope of the warranty, if the government specifies a design, the contractor's obligation to correct defects only extends to defects in material and workmanship or failure to conform to the design or specifications. But on the other hand, if the contractor specifies the design, the contractor's warranty will also need to extend to the usefulness of the design. Except for commercial item contracts, if you have an express warranty in the prime contract, it will negate any implied warranties. Keep in mind with the recent budget cuts that we've seen, although I guess they're not too recent anymore, unfortunately we've been suffering under them for a while, but federal government budget cuts may result and have resulted in an increase in government warranty claims. It used to be that if something went wrong in the vehicle, I believe the government just kind of went out and got a new vehicle. And with budget cuts, the government needs to fix what they have, and that has led to additional warranty claims. The FAR also provides that if there is a warranty, the warranty shall permit the government to, at a minimum, either obtain an equitable adjustment to the contract based on the defect, or direct the contractor to repair or replace the defect at the contractor's expense. It's important to know that a warranty obligation continues even after contract termination. There was a case in the Federal Circuit in 2007 where the government terminated for convenience the contract, but still required the contractor to provide warranty and upgrade services. And the Federal Circuit held that the Air Force had paid for the warranty and upgrade services as part of its purchase of the equipment, and therefore the warranty survived termination. So even though your contract is terminated, the warranty obligation will still survive. The FAR provides that if repair or replacement is not practical or it doesn't provide a sufficient remedy, the government may either retain the defective item and reduce the contract price accordingly, or arrange for the repair or replacement of the defective item by the government or another source at the contractor's expense. The duration of the warranty must be specified based on factors such as the estimated useful life of the item. If it's a vehicle, it might be in terms of mileage. The nature of the item, for example, does it have a certain sort of a shelf life, like a battery, and trade practice. If you are obligated under your prime contract with the government to fulfill your warranty obligation, well, what is included in your warranty cost? Well, it includes the cost of furnishing all labor and material to re-inspect the items that the government reasonably expected to be defective, accomplish the required repair or replacement of those defective items, and to test, inspect, package, pack, and mark the repaired or replaced items. It also includes transportation costs of both returning the defective item to the prime as well as to return the corrected, the repair part, back to the government, or a replaced part. Keep in mind, this is not necessarily the FOB point in the contract. You might have sent the product to TACOM here in Michigan, but now they're on vehicles that are in Afghanistan. So you would have to pay for the cost to bring the defective part back from Afghanistan here to Michigan or wherever you're located, and then also to send the repaired or replaced part back out to Afghanistan. Cost reimbursement prime contractors are a little different. Contracting officers are directed not to include warranties in cost reimbursement contracts unless authorized in accordance with agency regulations, and there's also some FAR clauses I identified there that do have a scope of warranty. Under both of those clauses, the contractor is required to replace non-conforming parts or goods or services, and the replacement costs are allowable costs under the contract, meaning you get paid by the government to perform those repair or replacement activities. However, there are some caveats, and one is if the contractor doesn't promptly repair or replace. Also, if the nonconformance is due to fraud, lack of good faith, or willful misconduct on the part of the contractor's managerial personnel. And then the last is if the nonconformance is due to a habitually careless or unqualified employee, where the contractor knew that employee was habitually careless, unqualified, and still allowed them to perform work anyways. Note the contractor, though, is not entitled to receive any additional fee on the replacement supplies or services. And further, if the contractor doesn't comply and promptly repair or replace the goods or services, the contractor's fee can be reduced. And last, even under a cost reimbursement contract, you can't blow off the warranty because failure to promptly repair or replace can also result in a termination for default. Last type of contract is a commercial item contract, and the FAR requires contracting officers to take advantage of commercial warranties, including extended warranties, where appropriate and in the government's best interest. It may be, too, that you might see a commercial item solicitation where the contracting officer has specified parameters for the express warranty, for example, a minimum duration, but it does not set out the explicit requirements for the warranty. In the clause that's in prime commercial item contracts, which is FAR 52.212-4, paragraph O provides the standard warranty. And it's the contractor warrants and implies that the items delivered hereunder are marketable and fit for the particular purpose described in this contract. Well, that sounds familiar. Those are the implied warranties that Vanessa was just talking about. Keep in mind that under the FAR, some of the paragraphs in FAR 52.212-4 can be what's called tailored or changed. And that paragraph O, that warranty clause, is one that can be changed and negotiated with the government. So if you are a commercial item contractor and you do have a standard express warranty, I strongly recommend that you, in your proposal to the government, switch out that implied warranty language for the express warranty language that you're proposing so that you do not get stuck with those implied warranties. Also, note that, as Vanessa stated, we're talking about the UCC today, which only applies to the sale of goods. So this warranty is really a warranty for the sale of goods, but it's also used in contracts for services. So that definitely gives the contractor a good basis to object to that warranty language in contracts for services and ask for replacement language. The FAR also expressly states that in some markets it may be customary commercial practice for contractors to exclude or limit the implied warranties, and that's what we were just talking about, excluding the applied warranties and replacing them with express warranties. And the only restriction is that the contracting officer needs to ensure that the express warranty that it accepts provides for repair or replacement of the defective items that are discovered within a reasonable period of time after acceptance. So on warranty, the key takeaway when drafting subcontracts is that the scope and length of the warranty from the subcontractor should parallel the prime's warranty to the government. So the scope is what does the warranty cover. The length needs to take into account the delivery delay and manufacturing delays between when the sub delivers it to the prime and the prime delivers it to the government. And then it also should clearly identify what triggers the warranty. So for example, you might have a 12-month warranty in the contract, but when does that 12 months start? Does it start from acceptance, delivery, payment? You want to make sure that's identified, because if you're at the month 11 plus 20 days mark, it may become critical as to when that warranty has begun to run. Now I'm going to turn it over to Vanessa to talk about changes in commercial contracts.
In the commercial world, in general, contracts may not be unilaterally modified without the consent of both contracting parties. Changes clauses that we see in commercial contracts will vary greatly depending upon the bargaining power or leverage between the buyer and the seller. It's important to pay attention to details in the contract as to what can and cannot be unilaterally changed and what happens if a change occurs. We've seen contract provisions where the unilateral change rights were just far too broad. For example, where the buyer reserves right to make changes to drawings, designs, specifications, instructions of the purchase order, method of shipment, packaging, place of delivery, quantity of work, scope of work, etc. That's just far too broad. It doesn't protect the seller from costly and last-minute changes that are going to severely alter the scope of the contract. So be careful that the change provision is not so broad that it allows one party to unilaterally change what's the basis of the bargain between the parties. And then change clauses, when they are allowed in the contract, should set forth what is permissible and what is the process for tying the change to cost requirements under the contract. For example, is there going to be a formula allowed for price adjustments that occur during the course of the contract? Will the buyer have sole discretion as to whether to adjust prices despite raw material increases? Will there be equitable price adjustments or only for cost impact changes? My recommendation is get a formula in place or have some threshold in the contract as to what constitutes a change that would allow for a price adjustment. Most written agreements will contain a requirement that modifications have to be in writing, signed by an authorized representative from each of the parties. And a common question we get is, do emails constitute writings? Most states have found they do. It varies state by state, but the majority of states have found that emails are sufficient to satisfy the writing requirement under a changes term. Now, the requirement that a modification or a change to a contract be in writing does not mean that oral modifications will automatically be barred. Even verbal agreements can constitute modifications if there's a meeting of the minds between the parties. So if the parties conduct themselves as though the change occurred and they both have accepted the change, then courts are going to look beyond the language in the contract, even where it required something in writing, and they're going to require the parties to be bound by the modification. The key takeaway here is if a party presents clear and convincing evidence establishing mutual agreement to the change, then the change will be enforced by courts under the UCC.
So for prime contracts and non-commercial item contracts, the government has the right to unilaterally issue change orders within the general scope of the prime contract. When the government does so, the prime contractor can then request an equitable adjustment, an REA, in terms of the cost or schedule extension, or both, that are resulting from the change. The contractor must proceed with the work as changed, even pending a disagreement with the government on the amount of the REA. On the other hand, for commercial item contracts, all changes must be mutually agreed upon by the parties, again, similar to what Vanessa described in the commercial marketplace. Although for those of you in the automotive industry, I do think that oftentimes, sometimes some things like this are now unilaterally directed by some of your customers. You might see that more and more. Also, in some, like the aerospace industry as well, and even in the commercial context. The next topic is about what constitutes a change under the changes clause. And here I've just listed for goods and services the different types of things that could be changed. But the most important point here is that the terms and conditions of the contract cannot be changed. So, for example, the warranty term is not something that can be changed unilaterally. And the government also cannot issue cardinal changes, which are changes are outside the scope of the contract. They cannot order a car and decide that they instead want a boat. That is unacceptable. When you do receive a change from the government, you need to give the government written notice of your intent to submit an REA within 30 days from receiving the written order. The contracting officer retains the right to receive and act upon the proposal that's submitted before final payment. So although there's that 30 days in the FAR clause, it's not an absolute bar, but final payment on the contract is bar. So it's important that you must give notice before final payment and submit a claim. And the best practice, though, is just to give notice within that 30 days and avoid the issue entirely if possible, something that you don't want to have to litigate down the road. So from the prime's perspective, the prime needs to slow down to the subcontractor the ability to make unilateral changes in line with the changes clause it's accepting from the government, especially in non-commercial item contracts. The prime can do so by either slowing down the applicable FAR changes clause or to put in full text its own contract clause. The prime needs to shorten the notice time periods in the clause. So, for example, since the prime only has 30 days to submit an REA, the prime's going to only want to give its subcontractor 15 or 20 days to submit its REA so that the prime has enough time to take the sub's REA and incorporate it into the prime's REA. The prime's going to want to require the subcontractors to continue performing the contract as changed, even while the amount of the REA is still being decided, and also should provide that failing to agree on the amount of the REA should be a dispute under the disputes clause of the subcontract. In the event of a government bilateral change, you could have that changes are mutually agreed upon between the prime and the sub as well. And you should also have that it's the prime contractor's receipt of final payment that should be a bar to the subcontractor's submission of REAs or claims, because that's the point at which the prime can no longer submit those REAs to the government. Now, on the other hand, from the subcontractor's perspective, subcontract should draw a distinction between when there's a government-directed change and a prime-directed change. So often what we do is we include, if the FAR clause is being incorporated into the subcontract, we'll include a parenthetical saying that the right to unilaterally direct changes is only when the change is directed by the government, and all other changes must be mutually agreed upon by the parties. Also, you should want to make sure that the disputes clause reference is the disputes clause in the subcontract. Again, not the prime contract disputes clause, which does not apply to subcontractors. In terms of the requirement to proceed with the work as changed, again, it might be different if it's a change unilaterally directed by the government versus one that is just being unilaterally directed by the higher tier contractor. And then final payment as part of the submission of claims. The subcontractor should understand that that's the point at which the prime can no longer flow that up. But I was just looking at a contract yesterday that limited the subcontractor's ability to submit claims to a year period. And that's not fair because the prime really has up until final payment to submit it. The subcontractor shouldn't be arbitrarily tied to some sort of year time frame. So the next topic we're going to turn to is termination for default. Under a government prime contract, the government can terminate for default if the contractor fails to deliver the supplies or to perform the services within the time specified in the contract or any extension. Also note that the government, though, will waive its right to terminate for default if the government doesn't exercise that right within a reasonable time and the contractor relies to its detriment on the government's forbearance. For example, the boards have found a waiver when the contracting officer told the contractor to continue performing and proposed a new delivery schedule. Even though the contractor never accepted that new delivery schedule kind of extended the due date, and the government could no longer terminate for default because the contractor was late. Following that waiver, however, the right to terminate can be reestablished by the government, either by giving notice of that new delivery date. So in the example I just gave, if the contractor then breached that second delivery date, they would then again be late, or through a bilateral agreement. If the date's unilaterally established by the government, it must be a specific date and reasonable. It can't be, for example, the day after the original deadline. Another reason the government can terminate for default is failure to make progress so as to endanger performance of the contract. And the last is failure to perform any of the other provisions of the contract or comply with any terms and conditions in the contract. Although it talks about all terms and conditions, the government and boards have read a materiality requirement. So it has to be a material requirement of the contract, not just any requirement. Some examples are failure to obtain required licenses, failing to perform duties under the warranty clause, failing to provide required insurance certificates, and failing to maintain or provide required records. Those have all been found to be an adequate basis on which the government could terminate for default the contract. Under prime contracts, the government must give a show cause notice or cure notice period to the contractor. There is no notice requirement, though, if the termination for default basis is because the contractor's late. Then the government does not need to give a show cause or cure notice to the contractor. But otherwise, it typically provides that the contractor has 10 days to show cause why the contract should not be terminated or otherwise cure the default. Although commercial item prime contracts don't have a specific show cause notice in the clause, the FAR in FAR Part 12.403 provides that the contracting officer shall send a cure notice prior to terminating a contract for a reason other than late delivery. So it doesn't have that specific 10-day period, but it does encourage that type of notice. For commercial item contracts, paragraph M addresses terminations for default, and it just provides that the government's not liable to the contractor for supplies or services that it did not accept, and the contractor is also liable to the government for any and all rights and remedies provided by law in the event of a termination for default. In fixed-price non-commercial item contracts, the contractor again only receives payment for the work that's been accepted by the government. When the contractor is manufacturing goods, the contractor is not entitled to payment for work in progress unless the contracting officer requests delivery of what's called manufacturing materials. Keep in mind that the definition of manufacturing materials includes partially completed plans, drawings, information, and contract rights that are produced or acquired for the terminated portion of the contract. That may involve the transfer of some of the contractor's intellectual property rights to the government. It provides the price for those manufacturing materials to be negotiated, but that is something that I think many people don't realize is in that standard FAR clause, and is something that the contractor should be aware of in the event of a termination for default in a manufacturing contract. If there is a termination for default, the government then has the right to reprocure the goods. They can reprocure similar goods and services. It does not need to be identical. It just needs to be similar. And to the extent it's not identical, the excess cost for the similar good, it can be adjusted to account for the differences in items when the contractor needs to pay the government for reprocurement costs. So in a termination for default, the contractor needs to pay the government for the difference between what the government was going to pay the contractor and what the government ended up paying for the similar goods or services. Similar means it needs to be similar in physical and mechanical characteristics as well as functional purpose. There's no similarity requirement in the construction FAR clause for those construction contractors, but boards have held that a similarity determination does exist even in that clause. Also, when reprocuring, the government cannot materially alter the terms and conditions of the original contract. And if the replacement goods and services are found to not be held similar, then the government loses its right to recover any excess reprocurement costs from the contractor. So, for example, the boards have not permitted the government to adjust the excess costs to account for the differences like they do between similar versus identical. So that if you have been terminated for default, and the government is assessing reprocurement damages, one of the things to take a look at is the reprocurement contract. Is the government procuring similar or identical goods? And if it's not similar and you can make that argument, you may be able to get out of paying those reprocurement costs. The government has a duty to mitigate its damages, though, so the government needs to act reasonably in selecting the reprocurement contractor and establishing the reprocurement price. The government also must show that the costs were actually incurred before being able to recover against the contractor. So that is when the reprocurement contract is completely performed and the government has made payment to the contractor. The government can recover reprocurement costs during the entire reprocurement period, even option years, if it was in the base contract. So if you had a one-year contract with 4 option years and you were terminated for default in year 1, even though the government had not yet exercised the options, you would be on the hook for reprocurement costs for the base year plus all 4 options. Also, if the contract permits the government to recover liquidated damages, that's in addition to excess reprocurement costs. Also, the government can recover any actual damages that aren't recovered through the excess reprocurement costs, although if the government's getting liquidated damages, they forfeit the actual damage recovery. And then also administrative costs of reprocurement. For example, the Defense Logistics Agency builds that already into the contract and has a set amount that they're owed for administrative reprocurement costs in the event of a termination for default. For cost reimbursement contracts, the contractor does receive reimbursement for all costs incurred prior to the termination. A contractor is not liable for reprocurement costs. The only downside, I guess, there are a few in a cost reimbursement contract. One, the government can reduce the fixed fee. And last, the cost of preparing the contractor's termination settlement proposal is unallowable. However, even under a cost reimbursement contract, there's adverse consequences for termination for default. Under the certification in FAR 52209-5 regarding responsibility matters, contractors need to certify whether they've had a termination for default in the last 3 years. That then becomes a black mark on the contractor's record and may impact future responsibility determinations and their ability to get another prime contract in the future. If you do have a termination for default, you can contest it with the government, and the main way to do that is to argue that the termination for default was improper. And you could do that by demonstrating either you were not in default or that your default was excusable. And in order to be excusable, it needs to arise from a cause that is outside your control and without your fault or negligence of both you and your subcontractors. If you're successful, either directly with the government or through litigation, through the Board of Contract Appeals or the Court of Federal Claims, in getting the termination for default lifted, what happens is that termination for default is converted to a termination for convenience, in which case the contractor will not be liable to the government for reprocurement costs. The contractor can submit a termination settlement proposal and recover for those costs that were incurred for work performed but not accepted by the government prior to the termination. And the contractor will be made whole. It won't get lost profits like it doesn't under a termination for convenience anyways, but it also will no longer have that black mark on its record. Vanessa's now going to talk about termination for default consequences in subcontracts in the commercial context.
So just like in the government setting, in the commercial setting, a contract can be terminated for cause or for default. The termination provision should contain all the details of the reasons giving the parties the right to terminate, as well as the procedures of termination and the effect of such termination. Clauses for termination for default can be simply stated and just say, termination upon breach, or they can include a detailed, specific list of grounds warranting termination. The clause may provide that the breach of a material provision of the contract that is not cured within X number of days is a reason to terminate for default. Materiality is very important because you don't want some minor infraction blowing up a long-term supply agreement, such as the failure to properly package or label a shipment, ending a long-term agreement. It doesn't need to only be for breach of performance obligations under the contract. Termination for default may be triggered upon the occurrence of a number of other events. For example, assignment of the contract, insolvency of one party, or bankruptcy. The effect of termination for default in the contract, it should set forth what happens. when there's a termination for default. It might list a broad range of potential damages, such as expectation damages, which include the benefit of bargain costs or cover costs. Aaron talked a lot about reprocurement costs, very similar to cover costs, and the duty to mitigate also applies. Goal under expectation damages is to make the injured party whole, as though the contract had been fully performed. Also consequential damages, lost profits, and then incidental damages, which include things like cost of inspection, sorting costs, receipt, transportation, and then costs related to rejected goods. These are a lot of internal damages, and whenever a breach arises, we counsel companies to immediately begin tracking all categories of damages, but particularly the incidental type of damages that are internal costs your company is incurring, time spent on conference calls, space and time allocated for sorting, things like that that are going to be more difficult down the road to keep track of if a future litigation arises. Termination for default also can give rise to other categories of damages, such as punitive damages, which are fairly rare in contract cases. There might be liquidated damages, meaning a set amount of damages set forth in the contract that's pre-negotiated and stated in the event there's been a breach. We'll talk a bit more about that later. And the contract also can call for certain equitable remedies, such as the right to seek an injunction or specific performance in the event of a breach. This is common where the goods are supplied on a just-in-time basis, they're specially manufactured, and you know that there's not going to be an alternate supplier available, or there's a lengthy approval process or PPAP process to get a replacement supplier in line. You see it a lot in automotive or aerospace industries. The contract might expressly recognize that you have the right to seek equitable remedies such as an injunction or specific performance, but beware that courts still will scrutinize whether injunctive relief actually is appropriate under the circumstances. Having the language in the contract will help, and it's something that you certainly should point to, but that doesn't mean that you're going to get the injunctive relief you're requesting.
So from the prime contractor's perspective, what you'll want to do is make sure that you're clearly identifying in the subcontract the events that support a default for the subcontractor. For example, sometimes it's broader than just what's in the FAR clause. It's breach, insolvency, cost competitiveness, change in control. Those are some of the ones that are not in the FAR clause, but the prime might want to consider including in the subcontract. And also the prime needs to shorten the time period to respond to a cure notice from 10 days to something shorter like 7 days. So again, if the default is based on your subcontractor's default, you have enough time to work the subcontractor's response into your response to the government. From the subcontractor's perspective, it's the opposite. You want to limit the prime's right to terminate for default to those reasons that the government could terminate for default. Also make sure that the clause clearly states that delays caused by force majeure events, which are beyond your control and without your fault or negligence, do not qualify an event of default. And also should try to limit default terminations to those that constitute a material breach or a breach of a material requirement. Last, subcontracts should also have a viable dispute resolution process for disputes regarding the default action. Maybe it's talking members of management of each company talk, and then maybe it's mediation, alternative dispute resolution, arbitration. Maybe there's a escalating process. If you need CLE credit, you now see a box, and I'm going to read a code for you to input so that we know that you are still listening. So that code is 49W as in whale 8. Again, that is 49W as in whale 8. So I will give you a few seconds to input that. The last time is 49W 8. And if you did not get that, please shoot us a note, and especially if it was unclear. Okay, moving along then to termination for convenience. This is now Vanessa going to talk about termination for convenience in a commercial context.
Sure. Contracts may also include a provision that allows one or both parties to terminate the contract for convenience. That can be for without any cause or any reason whatsoever, so an at-will termination of the contract. We'll see this unilateral right if one party has much more bargaining power than the other party. It's rare to really see joint termination for convenience provisions in a contract, allowing both sides to terminate for convenience. Sometimes this has the effect of turning a long-term agreement into an order-by-order type of contract. If one party is displeased with the quality or the price they're receiving, they can terminate for convenience and then continue to issue purchase orders order by order while trying to ramp up another supplier. If there's a very open-ended right to terminate for convenience, it really becomes an order-by-order agreement between the parties. We caution suppliers to negotiate in obsolescence provisions and to have some mechanism for recovering capital, tooling, or investment costs in the event that the buyer operates the termination for convenience mechanism. It should be, when you're looking at obsolescence, you need to look not just what falls within the time frame of your own production line, but you need to look downstream and see, whether you're going to have raw materials costs or costs from your own sub-suppliers because you order parts months in advance and they're on boats overseas coming to you. So make sure any obsolescence provision that's tied to the termination for convenience includes your full obsolescence downstream and potential costs in the event of a termination.
Well, Vanessa talked about bargaining power, and we know in prime contracts who has that power, and that's the government. So in prime contracts, the government can always unilaterally terminate for convenience the prime contract at any time, and that also applies to commercial item contracts. The only limitation is that the government may not do so in bad faith, but bad faith is a very high standard that is very hard to meet. For a fixed price non-commercial item contract, when the prime receives a notice of a termination for convenience, they need to stop all work on the terminated portion of the contract, stop placing subcontracts, cancel existing subcontracts, and deliver to the government all completed work and all material acquired for the work terminated. The prime has a duty to mitigate costs. So, for example, if you could use materials you purchased for another contract, you should do so, although you also need to submit termination inventory schedules. So you need to be careful that if you've identified property on a termination inventory schedule, but you can then use it for another contract, you need to get the government's permission before doing so, because at that point you're identifying it as potential government property. The contractor must submit a final termination settlement proposal to the government with 1 year of the effective date of the termination. And basically the contractor gets paid for all costs they incurred prior to the termination, including startup and preparatory costs, as well as costs they incur in preparing the termination settlement proposal, including use of consultants such as lawyers and accountants. Again, we are reimbursable under a termination for convenience settlement proposal. So we encourage contractors to get us involved early in the process, get some government contracts accountants involved early in the process. And as Vanessa was saying, it's important to track the time that you spend internally in putting together a termination settlement proposal, because that is also recoverable as part of the termination settlement. Although the calculations are subject to the cost principles in the FAR, they're usually used as a guide, and it's not strictly enforced in a fixed price contract. For commercial item contracts, it's a much more simplified process. It doesn't have all of those specific requirements, but the prime's allowed to receive a percentage of the contract price that reflects the percentage of the work performed prior to the termination, as well as reasonable charges resulting from the termination. The clause specifically says that the prime can support these figures with documents from its standard record-keeping system, and you do not need to comply with the cost accounting standards or cost principles. So from the prime's perspective, again, this is not a required flow-down clause, which is interesting. I'm seeing the slides not coming up potentially. There we go. It's not a required flow-down, but prime should flow down the clause to all subcontractors, as we talked about earlier, so they're not exposed from a business perspective. The prime should provide subcontractors with an opportunity to submit a termination settlement proposal, but they're going to want to shorten the 1-year period for both the submission of the termination settlement proposal and the 120-day period for the submission of termination inventory schedules, so that the prime has the ability to incorporate it in what they're submitting to the government. Note, as a prime, the subcontractor does not need to accept a termination for convenience for the prime's own convenience. So again, that's going to depend on the bargaining power. And the prime is going to want to try to limit the subcontractor's recovery to the recovery the prime actually gets from the government if it's a government-directed termination. From the subcontractor's perspective, the subcontractor should try to distinguish in the contract terminations that are directed by the government for the government's convenience and those that are based on the contractor's own convenience. One caveat to note is that if the prime contractor includes the termination for convenience FAR clause in the subcontract and has a substitution of parties such that references to the government mean the prime contractor, that in essence gives the prime contractor the right to terminate for its own convenience. So again, you might want to put a parenthetical after that clause if you're a subcontractor that says the right to terminate for convenience only applies to the extent it's directed by the government. And last, the subcontractor now knows what it is that the prime can recover from the government in a termination for convenience, and it's going to want those same rights as well. So now we're going to move on to innovative techniques to reduce risk. And the first is subcontract slowdowns, which we've talked about today. And you can do that in two ways as the prime contractor. The first is to include the same FAR clauses in the same format that they are in the prime contract. You'll want to include a statement replacing references. So references to the government mean the prime, contracting officer means the prime's representative, so on and so forth. You'll want to shorten the notice period so that the prime has enough time to incorporate the subcontractor's work product into what it submits to the government. And it's also important to make sure that you have the same version. After each FAR clause, there's a date. And those clauses often change, which I think keeps me in business because they're constantly changing. You'll want to make sure that you are flowing down to the subcontractor the same version that is in your prime contract, which may not be the most recent version of the clause. Since all FAR clauses are really contract clauses, the prime can develop its own clauses and include them in full text. They'll just need to make sure that they're covering all the risks and liability they have to the government and ensure that the clause is enforceable in their jurisdiction. I often see both FAR clauses and commercial clauses being flowed down. For example, the commercial clauses will include a termination for convenience, and the FAR clause would also be included. And they're not necessarily consistent. So you'll want to make sure as the drafter of the agreement that you go with one approach or the other, but it's not usually good to go with both. Indemnification is also another technique to mitigate against risk. There's no FAR clause that requires contractors in fixed-price contracts to indemnify the government for loss or damage to person or property that occurs after the government's acceptance or results from defects or deficiencies, similar to what we typically see in the commercial contracts. However, the prime does have liability obligations for loss or damage to government property in the limitation of liability clause if that damage is caused by willful misconduct or lack of good faith on behalf of the contractor's managerial personnel. So contractors need to carefully review solicitations and contracts for indemnification clauses because, again, it's not a set FAR clause that you would see. It would probably be a clause that is in full text elsewhere. In terms of indemnification in the other direction, just a side note that the government cannot indemnify the contractor absent certain circumstances. It's a violation of the Anti-Deficiency Act because the government can only spend money that has been appropriated, and indemnification funds would not be appropriated money. Now, there are exceptions if the government's liability under an indemnification clause is capped and there's appropriations that are sufficient to cover that cap, and so, or otherwise if it's authorized by statute or regulation. But generally, if you're looking for the government to indemnify you, it's going to be an extreme uphill battle. Vanessa's now going to talk about indemnification under commercial contracts.
So in a typical indemnification provision in the commercial setting, the seller agrees to protect the buyer against damage or loss it may incur to third parties. There are several common bases for indemnification, which we've listed here, and then there's also several categories of conduct that require indemnification. Commonly see IP infringement indemnification, indemnification requirements for negligence or gross negligence. The clause should set forth who will be indemnified, the buyer, the buyer's affiliates, or the customer. And then the scope of costs recoverable through the indemnification clause. Is it all liability? Does it include attorney's fees, costs of litigation, or settlements? There should be a requirement to notify the higher-tiered contractor of the third-party claims within a reasonable period of time. We want adequate notice, enough time to review the claims, and then make a decision regarding whether or not the claims are covered by the indemnification provision. You don't want them coming to you a day before the answer is due that they have to file. You don't want the party to proceeding to settle the claims without you pay a judgment that you might have good defenses to before seeking indemnification and without your company's involvement in the negotiations or lawsuit. It should also include in the indemnity provision a clause that addresses the prime's involvement in the litigation or the buyer's involvement in the litigation. You want to keep them involved because you'll need facts and information from them, so you need their assistance defending the lawsuit. You may want to cover in the indemnification clause who's going to control the lawsuit and retain counsel, make those sorts of decisions. Other ways to manage risk are to include very important limitation of liability and limited remedies provisions in your contracts. Parties to a contract may always agree to fix or limit remedies or damages within certain bounds. It can be accomplished by either agreeing to limit remedies, which are the avenues of recourse available to a party, or agreeing to fix or limit damages, which is money. There are several important reasons that companies may decide to include limitations on liability. Or limited remedies. One is that you want to be able to reduce your risk. You want some predictability as to how much exposure your company has. And this is all very important for business planning purposes. For example, a number of companies will include in their piece price or their long-term agreements certain assumptions as to liability down the road. And these need to be built into financial models for the company. The UCC permits parties to limit or alter available remedies. When a contract sets forth limited remedies, it's important that the contract not only lists those limited remedies, but also state that they are exclusive. Without that exclusive language in there, there's going to be a presumption that the remedies are cumulative to or in addition to other remedies, and that will open up all the remedies available under the UCC. There are two types of limited remedy provisions. The first we commonly see is the sellers restricting the buyer's remedies to repair or replacement of the nonconforming goods or services. And then the second type of limited remedy is to credit for the goods returned or the defective services performed. Now, a common defense to the enforcement of a limited remedy provision is that it fails of its essential purpose. If a remedy fails of its essential purpose, it's unenforceable, and then the buyer can go back to the UCC to all remedies available under the code. So let's talk a bit about what it means for a remedy to fail of its essential purpose. A remedy will be deemed to fail of its essential purpose where, for example, there's an exclusive repair remedy, but repeated repair attempts don't fix the issues. The UCC recognizes that it would be inherently unfair to limit the buyer to that remedy because it's not working to resolve the issue. So the key is that the buyer needs to be provided with some avenue of relief for the remedy called for in the contract. If the buyer can't make that limited remedy available or can't receive that limited remedy, then the remedy has failed of its essential purpose. As long as there's minimum adequate remedies left for the aggrieved party, the limitation on remedies is not going to be deemed to fail of its essential purpose. We talked earlier about implied warranties and the dangers that can occur when you don't properly protect yourself from implied warranties by excluding them. Now, with respect to express warranties, once an express warranty is made, it cannot be disclaimed. We've seen situations where sellers try to disclaim an express warranty, But you can't do that. The disclaimer is going to be stricken because the express warranty is really the heart of the agreement, so you can't get rid of it. But when you can, you should try to limit or exclude implied warranties. Disclaimers of implied warranties generally are deemed to be enforceable as long as certain requirements under the UCC have been met. Then the way to do it is through express language in the contract that specifically mentions the word, for example, implied warranty of merchantability or implied warranty of fitness for particular purpose. So use the terms, make sure the language is conspicuous, and that's about all you need to ensure that they're disclaimed. The other pitfall to avoid is the danger that the disclaimer will be deemed unconscionable. The unconscionability defense, it requires the other party to show that the disclaimer would shock the conscience if it were to be enforced. But it's very difficult to establish unconscionability, especially in the commercial setting between two companies. You would need both substantive unconscionability, meaning that the disclaimer was unfair, as well as procedural unconscionability, meaning that the mechanism in which the parties reached the disclaimer in the contract was unfair, which is difficult to establish. So watch out for situations where the express warranty actually includes language that the part must be merchantable and must be fit for the purpose intended. Because now you have taken implied warranties and made them express warranties, that the disclaimer will not serve to remove those warranties. Damages are another area that parties should negotiate. Exclusion of certain categories of damages, such as lost profits and other consequential, incidental, special, or punitive damages. We also see companies negotiate a damages cap or a ceiling that will apply in the event of a breach. Sometimes it's limited to the purchase price. Other times we'll see it some multiplier or a fraction of the purchase price. There is no FAR provision that prohibits companies from agreeing to a cap, so this is permissible. No magic language is required. You just need to evidence a clear intent between the parties to cap or limit the damages available under the contract. Just be sure that the amount offered is not so small that it could be voided as unconscionable. One more way to mitigate risk in contracts is to ensure that there's adequate set-off rights. Under the UCC, parties always have the right to set off against each other for claims from amounts owed under the same contract. Now, we recommend including cross set-off rights so that affiliated entities and under different contracts can also be set off in the event there's issues. Cross set-off is not permitted under the UCC unless it's expressly set forth in the contract. So it's important to have this tool available in the event that you're trying to recover amounts from what you owe. Finally, there's liquidated damages as another mechanism the parties can use. They can agree to an amount of damages, a predetermined amount of damages, at the outset of the contract. The key limitation on liquidated damages provisions is that it has to be reasonable based upon the conditions at the time of contracting. You're not looking at what would be reasonable at the time the breach occurred, but rather, is this the type of breach that the parties contemplated at the time they entered into the contract? And then are these the type of damages that the parties anticipated would flow from that breach? To look at whether or not the liquidated damages are reasonable, courts look at three different factors. And the first is whether the anticipated or actual harm caused by the breach was contemplated at the time the parties entered into the agreement. If these were not the type of damages contemplated, they're not going to be allowed. Second reasonableness factor is it difficult to estimate or prove the damages sustained? Is it something that is not readily measurable, such that we should look to the liquidated damages provision? The third, which really relates closely to the second and courts treat it as the same, is inconvenience or non-feasibility of otherwise obtaining an adequate remedy. So if courts find that liquidated damages are unfair, unreasonable, or rise to the level of a penalty or a punitive damage, then the provision will be deemed unenforceable.
So the FAR also permits the government to assess liquidated damages, and those are addressed in FAR subpart 11.5. The contracting officer needs to consider the potential impact on pricing, competition, and contract administration before including a liquidated damage clause. And it should only be used when the time of delivery or performance is so important that the government may reasonably expect to suffer damage if the delivery or performance is delinquent. And the extent or amount of the damage would be difficult or impossible to estimate accurately or prove. We mostly see this in the construction context where the government needs to move into a building, but it's hard for the government to quantify what their damages would be if they couldn't move into the building on time because construction is late. Liquidated damages are not meant to be punitive, and they're not considered negative performance incentives. Basically, they're used to compensate the government for probable damages, and they must represent a reasonable forecast of the government's just compensation for the harm caused by late delivery or untimely performance. The government can use a maximum or amount or a maximum period for assessing liquidated damages. So usually you have a per-day cap, but it might have a total overall cap, or it would only be for up to 100 days, something along those lines. And they also could use more than one liquidated damage rate if the damage maybe wouldn't be so significant at first, but as the delay goes on longer, it might increase. But the contracting officer must take all steps to mitigate damages, liquidated damages, so they're not just assessing liquidated damages ad hoc. The next slide just shows a bunch of FAR clauses that provide for liquidated damage assessments, so feel free to peruse those at your leisure. So considerations for prime contractors, to the extent you have a liquidated clause in your contract, you will want to include in the subcontract the right to assess liquidated damages incurred by the prime as a result of the subcontractor's delay or default. And you also want to use the same rate in the subcontract that you have in the prime contract, or potentially even a higher rate if the prime contractor will also suffer damages that they would want to get compensated by the liquidated damages. But on the other hand, if you're the subcontractor, you want to make sure you're only accepting a liquidated damage clause if you know it's in the prime contract, and oftentimes I'll say, please show us proof it's in the prime. You want to limit the sum of the liquidated damages to what the prime's obligated to pay. The prime, again, may seek more, as I just suggested from the prime's perspective, but you could try to push back there. And then also only agree to pay liquidated damages if the delay or breach was solely your fault. Oftentimes we see it a little bit vague in the contract, and the prime may have the potential to recover the full $500 of liquidated damages per day from all 20 of its suppliers, and it's only liable to the government for $500 a day. That would be a windfall for the prime, and so you want to make sure it's appropriately tailored. How do you mitigate against being assessed liquidated damages and having delays? And the key is to maintain a critical path schedule, especially in construction, but even in manufacturing. To the extent the government causes any delays, you'll want to request contract extensions and make sure that you get modifications reflecting the schedule extensions. And you want to make sure if you're signing modifications and have not gotten the extension, that the modification does not include a broad release that could be held to say that you are waiving your right to seek that schedule extension. Another way to mitigate against risk is insurance. You have general liability insurance. However, general liability insurance does not cover damages to the product itself resulting from a defect in the product, which is basically a warranty claim. You can't really insure against that with a general liability policy. It usually, you only get coverage for injury to person or damage to property that results from the product defect. You could also get directors and officers liability insurance, and make sure you carefully review your insurance policies to understand what is and not covered. I have an aerospace client who had an insurance policy but didn't realize that aircraft was excluded, which really made that pretty useless for her business. And you'll also want to maintain adequate records to mitigate against risks. Again, if you need to demonstrate your critical path schedule to show that goods are not defective, if you need to show that any failure to perform was the government's fault and not your own, you'll want to make sure that documentation is critical. The contracting officer is the only one with a contracting warrant. So to the extent you've had conversations with a contract specialist or with engineers from the government, but not with the contracting officer, you'll want to make sure you have a paper trail and email the contracting officer and say, hey, we were just told by the contract specialist they want us to do X, Y, Z. If we don't hear from you, we assume that that is your direction and we'll proceed accordingly. That's the type of documentation you'll want to make sure you have. So we're going to address questions, but first we have one more poll question. And so again, if you're looking for CLE credit, you need to enter the second code. That second code is R as in rabbit, T as in tiger, 1, E as in eagle. Again, that is R as in rabbit, T as in tiger, 1, E as in eagle. And the last time is R as in rabbit, T as in tiger, 1, E as in eagle. So thank you for those who have submitted questions along the way. The first question we got was, do you consider DOE cooperative agreements a contract, and does the FAR apply to them? Actually, the FAR does not apply to cooperative agreements and grants. There are different regulations that apply to those. Sometimes some of the requirements mirror the FAR language, but the FAR clauses do not apply. The second question we had to relate to warranty provisions under cost reimbursement contracts. And the question was a good one about, if the ceiling of the cost contract has been met, will the government still reimburse for the cost of repair or replacement? Well, you are still subject to the limitation of cost, limitation of funds, FAR clauses, even in a warranty situation. So you're going to want to make sure that, to the extent the warranty work will put you above that cap, that you seek an extension or an increase in both those caps, either if it's a cost or funding issue, or potentially both. The next question had to do with commercial item subcontracts, and was I accurate, and did they hear me right when I said that commercial item subcontractors are not required to submit a small business subcontracting plan? And yes, that is the case. It's actually listed in one of the paragraphs of FAR 52-219-9. That's the small business subcontracting plan clause. Subparagraph J as in Jack says that subcontracting plans are not required for commercial item subcontracts, and you can see it there. The last question wanted some clarity on what is a set-off, so I'll turn that one over to Vanessa.
Sure. A set-off is when one party deducts an amount owed for a default, breach, or some other nonconformity from amounts payable to the other party. It's also referred to sometimes as an offset in the contract language.
So thank you very much for sticking with us to the end of our presentation today. You will see at the end there is our contact information. Feel free to contact us any questions. We are always available. And also you will have a survey that should be popping up on your screen. This is your opportunity to give us feedback. Tell us what you like, what you didn't like, especially for those who have been to our in-person seminars, whether they've been in Milwaukee or Boston. We have not provided that in the last year or so, but let us know what you think of this web conference format. Last, we will be holding our next annual seminar on Wednesday, October 14th at Schoolcraft College in Livonia. It again is going to be a morning seminar from around 9 to 12, including a complimentary continental breakfast and a complimentary networking lunch. This year we will be talking about commercial item contracting and supply chain management, addressing issues such as Buy American Act compliance, Trade Agreement Act compliance, specialty metals, counterfeit parts, and cybersecurity. I know those are all really hot topics these days, and for those who can make it, we appreciate it and look forward to seeing you. For those who will not be able to make it and really liked this setting, let us know, and we might again do a redo after our in-person seminar in the following spring. So thank you for your time today.
Thank you very much.